Welcome to Regulatory Ramblings. Our podcast today is brought to you by the University of Hong Kong's RegTech Lab, HKU SCF FinTech Academy, the Asia Global Institute, and the HKU edX Professional Certificate in FinTech, with support from the university's Faculty of Law. Artificial intelligence, or AI, has been much in the news in recent years, with apocalyptic headlines about how it will contribute to unemployment or underemployment by limiting jobs in some industries, and in some cases, perhaps even bring about the end of the human race itself. Hollywood has such an active imagination, but is everything that's fictional necessarily untrue? It's in that spirit that we look at the EU AI Act, the world's first comprehensive AI law, which is set to go into effect later this year. It's been called a groundbreaking piece of legislation aimed at ensuring better conditions for the development and use of AI, fostering benefits such as improved healthcare, safer transport, more efficient manufacturing, and sustainable energy solutions. It's unclear what the regulatory framework proposed by the European Commission will mean in governing AI systems across different risk levels. The intricacies of existing and emerging privacy regulation in the European Union and challenges facing in-house and general counsel will necessarily require clarity. Moreover, whether the US will take inspiration from the EU's approach and introduce similar rules and regs in the near future is an open question. Our guests today are Michael Borrelli and Anandaday Misshra. Michael is a director at AI and Partners, Europe's leading professional services firm, subject to the EU AI Act, leveraging 10 plus years of experience in financial services, compliance, and technology to help clients navigate the complex and evolving regulatory landscape of AI. He has a strong passion for responsible use of AI and its potential to create positive social impact while minimizing its risks and challenges. In addition to his role at AI and Partners, he's also serves as an independent director in finance and a fintech ambassador and an AI 2030 chapter advisor. Anandaday Misshra, who's been on our show before, is a veteran Indian lawyer and the founder and managing partner of AMLEGALS. It's a law firm with a presence in key Indian hub cities. The firm is a multidisciplinary firm in its approach and specializes in value and strategy in taxation, technology, commercial litigation, and arbitration. With over 27 years of experience as a lawyer and strategic advisor, Anand works with clients across various sectors and countries. Particular areas of practice include arbitration, data protection, privacy, contracts, employment law, taxation, and white-collar crime. He also handles litigation in India's various constitutional courts and has a rich experience in M&A deals, joint ventures, due diligence, and cross-border transactions. And with that, gentlemen, thank you so much for joining us.
Great to be here. Thank you so much for having me. It's great to be here to represent AI and Partners at a critical stage in the EU's regulatory journey with its imminent entry into force. And lots of things going on, so we can delve into some of that on the chat.
Yeah, looking forward to it. Yeah, let's dive right in. So what does the EU AI, why does the EU AI Act matter, and why is it coming into effect now?
It's a very interesting question. I think there are both philosophical or practical ways to answer this, but I'll probably go for the latter for sake of clarity. Why does it matter? Because the AI market is now effectively taking off, even though it's been around for a while, since the 1950s or so, thanks to Alan Turing. Obviously, he had his birthday yesterday, so a lot to thank for him there. But it's to regulate products sold on the market in the same way that you have for product safety. So similar to medical devices, cars, etc., they viewed AI systems as a product and subjecting those products to rigorous regulatory requirements. What is it, and why is it coming into force? What does it mean? Effectively means that from next month or August, the 2-year transition period kicks in. So similar to GDPR, there was a 2-year compliance window for companies to get all their systems, processes, procedures, etc. into place. With the noted difference, and this is the key caveat here, that there are staggered timelines. So under GDPR, you had 2 years just to get your things in order, and most companies waited to the last minute. Whereas the EU legislators this time have said, right, you've got 2 windows. However, within that 2-year window, there are staggered timeframes for compliance. For example, within the first 6 months of the 2-year transition period, companies have to identify and either de-risk or eliminate or decommission any prohibited AI system under Article 5.
That sounds pretty onerous. So if we take a step back and look at things more holistically and from a more macro level, what will it mean for the EU and the rest of the world?
It could be many things, and there are a lot of people with different opinions on this. I think one thing, it will require harmonization across the AI value chain, whether you're a provider, a user, a distributor, an importer, or any third party, including those supplying toolkits or service providers, to conform with your AI, with the requirements. We've termed it KYAI, Know Your AI System. So in the same way you do for KYC, when onboarding a client or dealing them, the way you treat them depends on the risk classification. The same concept applies for an AI system here. And it just means that you have to be very careful knowing what AI systems that you use and knowing how many. So in the same way you have an inventory of assets, an inventory of data like you did under GDPR, having an inventory of AI systems with the risk level abundantly clear for each is going to be absolutely essential, because if you're seen to be using or dealing with a prohibited system, it could result in 7% of global annual turnover or 35 million euros, whichever is higher, in terms of a monetary penalty.
Yeah, and some have said that's pretty onerous, it's pretty obscene. Thank you for that, Michael. Anand, what about the perspective from India? I mean, a lot of people have said they've drawn parallels to the GDPR, which clearly influenced similar rules around the world. India recently passed its own data privacy law. What does it mean for India? I mean, will AI take on a life of its own in India? Will it be left to its own devices, or will it most certainly be regulated? My sense is, Anna, that the Modi administration is of the view that AI must be regulated. It can't be allowed to take on a life of its own in India.
Yeah, thanks, Ajay, for having me second time in your program. There are many aspects to AI. It is not that only the AI system or AI technology what is going to. And of course, India comes with a very big population in the world. The challenges are totally different. And due to that, definitely, there are many more things going on, draft after draft being regulated. Even in the G20, we have committed that we will be laying down a benchmark for AI. And of course, AI is, of course, laying down a benchmark too. But there are many aspects which cannot be replicated in total, because EU has different dimensions, EU has different challenges, different population, different sets of risk factors, whereas India or this part of the world has a different way to deal with AI. And not only that, India also contributes very big numbers when it comes to AI or IT. So given with that factor, we are definitely gearing up, and DPDPA is already implemented. I mean, notified, it will be going to be implemented, and we already have many things going on with AI rules and regulation, Digital Act. So many transformation will come. And coming back to that, whether EU AI will matter and how India will be dealing with. See, I say there was a very big need of AI Act, whether it is coming in the EU or any part of the world. Because when we talk about AI, it's a technology thinking, technology dealing with data, and technology giving an outcome. And with a very dangerous situation that they have an autonomy. So unless it is regulated, it is unguided missile. So regulation has to be there in any part of the world. And good that EU AI has taken a lead and they have implemented. Of course, it will be notified in the next month also, and with a time frame of 36 months in implementation fully, a full implementation. And the basis what will be taken by entire world will be, of course, human FinTech, like what EOAI Act is also there. But there may be changes in the, not only on the purely on the risk analysis or the risk benefit analysis. There will be many things which will come in the due course of time. But of course, India is having everything in place, and very soon we will have AI Act.
Anand, I'd like to pick up on something you said that when it comes to AI, that it's about technology and it's about the outcomes, right? So in preparation for today's talk, I mean, I spoke to some people. I mean, I'm not a techie. I come from a liberal arts and a legal background, and a journalistic background. But I mean, having spoken to people who could be regarded as techie, certainly more tech savvy than myself, the impression I've been left with is that for AI to truly come alive will require advances in quantum computing, and that much of what's being touted as AI, it's not to say it won't be, all the benefits and the lofty goals that people say AI is going to achieve. It's not to say it won't happen, but it comes down to on what time frame will it happen, and that currently there's a mismatch between computing power and the ability to realize the gains and the benefits that AI advocates say will happen. So the claim is that right now what we see should not be taken seriously as AI. I'd like to hear your thoughts, and if Michael wants to chime in, it'd be key to hear from him too.
Ajay, this is something which we cannot neglect. We are already living with over a decade with AI, and in a full sense, we are already using it in every sphere of life. You name anything, and the latest interface based on AI model. It's not an AI model, but interface, what you call ChatGPT and all. So, or different versions. So we are already using it in the different spheres for betterment, for increase our efficiency, reducing many time period, so manforce optimization in medical space. But there are many areas, many spheres where we are already using it. So time has come when we are using it, we should know what exactly we are using, what the technology we are using, why we are using this, and that it is literally dealing with the data. I say whether you deal with GDPR or DPDPA, which will be in the India, we all are living data. Ultimately, whether you call subject principal data. So when we are dealing with our data, we as a human being, what exactly is going into and with whom it is being dealt, what is the outcome, and how it is impacting our atmosphere, our environment. So time was right then when this thing should have been regulated. At least what data are being fed, because there are many dangerous situations. Say if you are a policy for frame and you are making a policy for education, and the data or the data sets, what you are taking to make a policy for whether it's a senior secondary education or higher secondary education, maybe gender-based or age-based, their location, there are many factors. So what factor you are using, and if the data set what is going on, what is being used, or the data with which you are training our AI model, what AI system. So because AI is a set of technologies which is going into the AI system, and ultimately you are feeding the data, and whatever you will be feeding, you will be getting the output in the same manner. You cannot expect something miraculous when your data, what you're feeding is, whether it's biased or it doesn't take care of every parameter. So that's why the training, and so there are a lot of repercussions. So given that every part of the world has realized, and in fact, whether it is in G7 or time to time G20, everywhere it has been adopted in any part of the world. Of course, the view can differ in many parts of the world in what manner it has to be implemented. But That is something it was really needed. This is what I have to say.
Michael?
There's a lot of interesting points being made there. And what I think is essential to focus on is the data element. I think all these different conceptualizations of AI systems, both as products, both as services. I think at the moment we are facing a period of a definitional crisis, or what is AI, what isn't AI, and going down all these different roads. Focusing on the data element is key because it allows you to, for example, see what's being used to train the AI model, what page you have behind that, but also it's just one component of it. So taking more of a left field response to what Anand said, the AI data governance is key under the new AI Act, specifically Article 10. And I know I'm going very specific here, but I believe it's important the context of this conversation, because we need to understand what AI system is in the context of regulation if you want to adhere to it. And this is mainly from a practical commercial standpoint. There are many traditionalists and many academics who probably think otherwise. And whilst you have a legal versus academic definition, knowing what you're talking about, knowing what it is and what it isn't in the realms or through the eyes of the law is essential at this stage, because as this transition period approaches, that 2-year window is, and as Anand says, 36 months for certain AI systems is absolutely is critical.
When you look at the GDPR and you look at the EU AI Act, do they mesh well together? Do they fit well together? Do they gel well? Or do you see any potential basis for conflict between the two?
So there's various similarities and differences. So I think the best way to answer this question is how are they similar? So they're both similar. They're both risk-based. They're both, whereas GDPR regulates data based on its risk level. The same concept applies with the EU AI Act, albeit it's regulating its AI systems in terms of their risk to individuals' health, safety, and fundamental rights, because it's enshrined in the European Charter of Fundamental Rights, as well as Articles 114 and 16. In that sense, they're both. So that's where they're very similar conceptually. Now, in terms of how they're separate, now if you look at how they intertwine with each other or enmesh, there are a lot of crossovers. So, for example, if you want to train an AI system using sensitive personal data in a regulatory sandbox, which is one of the innovation measures, you would have to comply with the requirements under the GDPR. So any data touch points would be applicable there. There's also a new concept, and for those of your audience who are data privacy specialists will be of interest, there's something called a fundamental rights impact assessment under Article 27. This is the analogous equivalent of a data protection impact assessment on the GDPR. So where you undertake an assessment of the risk to data under the GDPR, you would have to do the same for a deployer of certain high-risk AI systems would have to do the same under Article 27. So there are crossovers there. And if you, at a very simple level, my business partner alludes to this, if data is the new oil or gasoline, then AI is the combustion engine. So on the basis of analogy, there are inevitable crossovers, both in terms of how they're similar and how they interact together.
Anand, anything to add?
See, the basis ultimately in both the cases, it's the data with whom everything is going on. So here the three terminology becomes very important. That will be data provenance, data governance, and the data lineage. Just like the entire cycle of the GDPR, if you will see, the data connection to the data disposal. Whatever way, why the purpose of data connection, what are the data processing, how you're documenting, what are the consent mechanism, and what are the life cycle, or whatever you can make it out from the GDPR. exactly as Michael rightly pointed out, impact, their data process, impact assessment. Here also you have to also see the impact assessment. The only dimension what you have to see is the risk or the foreseeable risk, reasonable foreseeable risk. Because it is not only human-centric, both the laws are human-centric at the first place. Second thing is risk. And if I will say to add why AI Act or the GDPR particularly, of course, GDPR for the data protection, data privacy. But here, if we will talk about EU AI Act, the recital 1 is very clear in the EU Act that the first priority is the health, the safety, and the fundamental laws, particularly for the, again, the coming to the human. So it's all about the data, whether the data sets with whom you are training your AI model. And again, whatever the AI model, there are different stakeholders, right? From the deployer to creator or importer, distributor, authorized agent, the many names of the import, particularly whether they are present in EU or outside EU. There are many various articles. So casting responsibility, obligation, but ultimately everything goes around the data, the risk factor, and the assessment. Here also the self-assessment, the risk assessment, the classification, particularly Article 51, how you take it. So there also the classification counts. So in GDPR also you see the data, what sort of data is. So here also you see what sort of risk factor is there in an AI model, accordingly you are putting it. The documentation, accountability, fairness, avoidance of biasness. So principle governing are more or less similar. But ultimately, you have to see that these models have been made out. And the very important thing, which Michael will also perhaps agree, when we talk about the AI itself, all over the world, AI we have particularly defined. AI when the definition is something which is an abstract, or the different things what we have made, whether we are guided by the OECD guidelines or whatever manner. But AI system, what we are more focusing on. So that is the only thing where we see, okay, here the focus is on AI system. Whatever you will find every places in the entire articles, you will find AI system to be the governing on the basis of which everything will be regulated. And the data definitely, Michael definitely took it in the proper manner that you are feeding, and this is the engine. So something like that, definitely, it is a standing in practice.
So if data is the oil of the new age and AI is the internal combustion engine, then clearly the engine can be impaired depending on the quality and the quantity of the fuel you're putting in. But I want to narrow the focus, if I may, that if we're looking at it from the perspective of one of the world's major banking or financial institutions, or a multinational corporation operates across borders. Okay. If you're a compliance officer or an in-house or general counsel, what are your concerns about AI? Michael, if I can turn to you first, given your compliance background, what should they make of AI? Should they be fearful? Should they be prepared? Should they look at it as an opportunity? What will AI do for compliance officers?
Well, I think this is the existential question that we're all facing, and I'd like to just touch on what Anand said earlier, and hopefully he agrees. AI is ubiquitous, so I think regardless of whether it is good, bad, or indifferent, and however you quantify those or measure those is objective and subject to each person. The fact that it's used everywhere means that it is at a risk. So things that could be contained are less of a risk because you can essentially manage it and it is in a contained environment. But because it's being used pretty much in all, both in social, political, economic sections of society, makes it a risk. Now, in the context of compliance officers at financial services, the fact that it is being used across the business is one, a risk, because you have to do a separate risk assessment across each business function and at a user level to see how people are using it. the risk level, when we talk about risk, and I'd like to go to definitions under the EU Acts. I believe Article 3, circle brackets 2, covers this in detail. And it is the risk to individuals' health, safety, and fundamental rights. So I have heard some people hold the view that is, because it's consumer protection led, it is aligned with retail types of activity. That is not the case. It is industry agnostic by de facto, by the legislative provisions, and it is also business model agnostic, similar to GDPR. So I think for compliance officer, understanding what it is conceptually and risk classifying it the same way you do for a client. So the concept of KYAI, know what you're dealing with, so then you can manage it properly. There's no such thing as risk free, but you can manage it. So if you know what the risk is and you can manage it as a compliance officer, it will make your life a lot easier. And then once you've taken those steps to get your heads around it, implementing a robust, a rigorous, an institutional grade quality onboarding program, including due diligence reviews to enable that you can manage the onboarding of new tools or how it's used and deployed within the business, similar to product governance under MiFID II, will make sure that you're safeguarding the business in the manner appropriate to its size, nature, scale, and complexity. But I'm very keen to hear what Anand says here.
Yeah, Anand, I want to tweak the question for you. I mean, what will AI as well as the EU legislation mean for, coming at it from an Indian perspective? So think about it in terms of you're an in-house general counsel at one of the major banks in Bombay, in Fort, in Nariman Point. You're sitting there. What will this mean for you? What burdens will this add to your daily routines? And or can AI be employed to make your daily requirement, your daily work more efficient? Can it be used to alleviate your burden, or is it just another risk you have to prepare for because no one knows where it's going to lead?
Yeah, well, Ajay, this is very interesting. The very first thing is definitely AI is going to help me, even as a GC or a particular banker or any organization, whether I'm
or
in
even
EU
or even
outside EU.
even a multinational, even just a transnational corporate.
Yeah, that's right. That's
Yeah.
right. Multinational also. There are very good reasons. See, the bedrock of entire AI or the GDPR or DPDP, everything is the trust factor. Ultimately, we are dealing with the human. That's why these all are human-centric. I have to say at the cost of repetition. So when I talk about the human-centric, the very first thing which comes to my mind, or even we refer to recitals, or in fact, we have 180 recitals in the EU AI Act. So even I am situated in EU or I am situated outside EU, I have responsibilities. I have a responsibility to declare. Say if I am a banker or you come on the interface, I have to declare that Ajay, you are dealing with a robot or an AI. That information I have to inform you at the first place. So that is my first compliance challenge. Previously or at present, if we are interacting, we consider, okay, it may be both or maybe a gentleman sitting a reply. So that information brings a transparency that with whom I am dealing with at the end of the conversation. So how my conversation, how my data will be dealt, that is again a prime importance. Secondly, I have to see in a different holistic manner. I cannot work as another person who have been working only in the GDPR. Because GDPR, if I will say, or if I will talk in how many or in how much manner with AI Act, EU AI Act, these laws complement each other. Along with it, EU AI Act also provides a window where your sectorial regulations also to be complied. And if those compliances are there, then somewhere there are very pragmatic changes where you are literally deviating from the basic bedrock of the EU Act with the risk. So there are many things which has evolved. It is not everywhere it is risk centric. Many times it is something for the innovation, because I will again come back to recital 1 to answer this question because that is very important and very prominent also. Michael must have definitely observed. See, there is some reason all over the world. The jurisprudence says if some words or expression deployed in any preamble or any enactment or a recital, and the manner it has been used, what has been used first, it really means a lot. And in the entire EU AI Act, the first word or the first recital is health, then comma safety and fundamental. So before fundamental rights, health has been given priority. It means a lot, or you can understand in such a manner. If the person's health is right, if it's safeguarded, then only he can enjoy the fundamental rights. So this is the one thing what anybody can draw by the choice of the words or the terminology used in the EUI Act, particularly first recital. Now coming back to if I am a GC or sitting even in Europe, say I'm in Europe, I am the deployer, I am the creator, I am the producer, whatever manner you want me limit, or I am taking AI model, AI system, which has been developed by a particular deployer outside EU, and I'm based in whether I am acting to deploy a position in the EU market as an authorized representative under a written mandate as the enactment provides, or I'm a deployer or the importer. There are certain obligations. So those obligations will be my first preference, that how I am fulfilling the obligations. Secondly, what are the risk module, whether it is complying with Article 2 at the first place or not. Then third is the risk parameters, so where I do stand. Then I will also see the risk assessment and I will document it, because the particular EI Act also mandates me various parameters, whether if I am an importer, distributor, deployer, or there are many things from Article 22 to 26. And there are many other particularly interplay. So these will be my first preference to see whether I am using it properly. If it is not, then I will not be deploying in the market, because the onus is on the self-assessment on the risk. There is a risk parameters. So I have to analyze that what are the risk element, what are AI system which I'm going to deploy, where it is classified, whether it is unacceptable or forbidden, then I have to wrap my show within 6 months from the day it will be notified. That is the first thing. High risk, okay, I have to ensure many compliances or obligations, information. I have to intended purpose or objective. I have to convey. I have to ensure with the management that whatever AI system is being deployed or given to the actual user, that particular information is going along with it, the intended purpose and as well as foreseeable risk factor. So on a lighter note, I have to act. I don't mean that I have to act as an astrologer, that what will be the star saying and all, but reasonableness is casted upon me. So these will be the responsibilities. It's not only about reading, but I have to be more on the technical side. So my role as a GC will be the TCL, techno-commercial legal, not only the commercial legal. Here I have got to understand the technical aspects of the entire EUAI Act, because AI itself, that's something, that's why I started, that AI itself has not been defined, but set of technologies, what they have used in the in particular recital. Whereas if you will see in any part of the section or articles, it is the word expression used is AI system. So these many things will be there, and only I won't be going only or purely with whatever I have implemented or the tools which I have used it for the GDPR. No, that will be too risky. Here I have to see in a different angle, one step ahead, because these were and even I have to also keep the records of an algorithm, what sort of algorithm is being fed into. And I have to also see the life cycle. So my job responsibility is more. In fact, one of the gentlemen I saw somewhere, he noted down that DPO can also play the role for observing for an organization for AI implementation. So there I'm afraid I cannot agree that no, because this itself will be a Herculean task. I think Michael will agree to it. So this will be there are many new dimensions which will be open. And you have to see that even in the EU, how early it will be implemented, how the states will be agreeing or disagreeing, because the fundamental rules and all will be also differing, not exactly in the total, because these are the broader framework which have been crafted. So, but even, and if I am outside EU, then also I have to see that, because ultimately my uh, business partner, if he will be in trouble, I will be in the trouble, and I have to see, I have to ensure that wherever the EU Act is responsible or is covering me under that domain, I will have to comply in the same manner. And the audit and accountability records, even the logs, somewhere it is 10 years also, I have to high risk, I have to keep it for the 10 years. So there are many things which comes. It is not an easy job. It will be a, what do you say, very, very tedious work, and for the first 2 to 3 years, but more tedious than GDP.
Yes, that is a word that came up quite a bit in some of the commentary I've seen on the EU Act and also the GDPR. I'd like to turn to the view from Asia, because what's concerning people, particularly in Singapore and Hong Kong and even China, is the rules by some have been construed to have extraterritorial effect. The EU doesn't typically do that. The US does. But in this instance, the EU, I don't know, somehow they've gotten a spine. They're acting they're acting bolder now. And so my question to both of you is, how will the EU AI Act impact businesses, organizations, and individuals operating both within the EU as well as beyond its borders? I guess the concern is what might be the effects externally. Should we fear extraterritorial reach and enforcement? Because obviously the EU doesn't have the kind of resources to make people comply the way the US does.
It's going to be difficult to see how aggressively it'll be enforced or not enforced, to the case may be. I think it's always good to look at the facts in the present. And if I give you an example, the Digital Services Act, the Digital Markets Act, two related regulations to the EU AI Act came into force this year. They've already issued 2 enforcement actions against some of the world's largest technology companies for significant fines, showing how aggressive that they could be with under this, because they foresee it as a necessary mechanism for consumer protection. In the same way that the number of users, I use this next term very carefully, as number of users increases, the risk level increases. So if you go on the belief of Metcalfe's law, where the value of the network grows in proportion to the number of users squared, then the same thing applies to AI. So more people using it amplifies the risk level, which necessitates a proportionate response for regulators. So it could be fair to say that the enforcement of this will be extremely aggressive. It will be done at the member state level, and each member state will then be accountable to the AI office, which is a new infrastructure already set up. So that will come into force, and they will be accountable there. So how Germany enforces it will be different to how France does it, and so on and so forth. But I think there's enough evidence to suggest that regardless of the market influences, this will be heavily enforced. And then you add on top of that the level of investment, the level of public interest as well, amongst other things. It gives you an indication that this will be taken extremely seriously on a global basis.
Thanks, Michael. Anand?
Yes, Ajay, there will be 2 parts which I want to deal on this print. Firstly, the business side. Definitely, it will be boosting business. So if I'm outside EU, then definitely I will be looking to comply with this regulation, because at various forums, all countries have shown their dedication and consensus to implement or to regulate AI. That is the factum, undisputed. With that, I will give you 2 examples, and then I will see whether the enforceability will be challenged or otherwise. 2 examples which I will see. If I will see EU AI Act, the live biometrics or live screening as a clear no. But if you come to Japan, they are using to watch, remote, particularly watching the students, how they are behaving in the school. So if their focus is not there for a stretch of 8 minutes, then they send a note to the parents that your child is not having focus.
How Orwellian! You realize this is already being used in classrooms in mainland China as well.
Yes, right. So this is a clear no. We cannot do in the EU Act. So say if some person is living in Japan, right? It is outside. So there will be a challenge. Now coming to the other,
but it works.
Thing, which is,
but clearly there's something implicit in what you're describing. Certain societies and cultures will tolerate more than others, right? The encroachment on individual liberties. There's a perception, rightly or wrongly, Asians will tolerate more encroachments on individual liberties than will those in the West or democratic world.
Ajay, to some extent, you can say yes, and to some extent, it is not every time yes also. I will come on that because this is a very interesting thing. And the second thing is the clear view. They're helping, in fact, Australian police also to AI scrapping, the facial recognition and all. So there were many cases. In fact, what I also came across that in UK, they won that case also. So there again, it is biometrics is a clear no in the EU AI Act. So there will be different dimensions that which jurisdiction will be agreeing to the structure layout, the framework of EU AI Act at the first place. If that jurisdiction is not agreeing, that will be the difference in it. But having said that, I'm a businessman. I want to deal with the EU, and I'm very much dependent on the AI and the EU. Definitely, I have got to comply, and the enforcement can be to some extent. It is not differing with that jurisdiction because even if you will see entire EU AI Act, there are many things where at some places it is very stricter version, and at some places it is not the 100% emphasis on the risk analysis. So both the dimensions has been adopted in EU AI Act. Of course, it is the first draft or whatever has the consensus been made. The lot many things will change, and even in the GDPR, if you will see facial expression, the very advanced rulings and various research, various papers, various strictures are coming. In fact, it is being dealt by the different data protection jurisdictions. So everything is mixed as of now. So lot many things will change. This is not the final thing. Maybe Michael has a different vision. What I can make it out, or Michael may agree with my thoughts. I'm just anticipating. So these are at the very first stage. It is yet to be notified in the next month. It will be notified, and then all the states or the members of the union will be implementing, and to what extent they will be having that leniency or how they will be changing. But definitely it is going to help the business because the trust factor will be more. And I think Europe will also be having good investments in the coming time because say if many investments have been declared so far with all the biggies. So, but every company is willing to, when they are aware that ultimately AI Act is going to come in every part of the world. So they want to start something in a compliant manner. So that will make them better structured so they don't have an unforeseen liability. And one thing I will definitely appreciate that they have understood one thing, that SMEs and the startups, they have created a wider version for every front. That is, of course, very welcoming.
Anand, I want to pick up on something you said, okay? That you said, okay, I'm a businessman. I want to do business with the EU, and therefore, in essence, you will have to comply with EU rules. But I'm thinking, though, if I were to reason by analogy, okay, let's look at Turkey, and let's look at countries like Poland and others. That to join the EU, basically, they had to change their societies. They had to change their laws. They had to make them more Western, more humane, more compassionate. They had to get rid of the death penalty. They had to change the laws. They had to become more Western than they were accepted the EU. Then then you look at a country like Turkey, okay, and they did all of that. They changed their laws. They tried to become more Western, but as the years passed, the EU would not have them in, okay, and then things changed. The European economy tanked, whereas the economic prospects for Turkey look good now. So could Turkey not say, to hell with it? Why do I need to abide by EU rules? Because I'm looking at the future and I'm going to be doing better than these guys. And reasoning by analogy, India is currently the fastest growing economy on earth. The figures that just came out today, by 2050, China is looking at a $49 trillion economy. That is it not conceivable that a country like India, a country like China can say, no, I'm not going to consider, this is not an earlier age. I'm not going to consider myself handcuffed by what the EU decides. Whereas in an earlier age, if you talk to people, once the Americans and the Europeans decided something at the WTO, it was a done deal and the rest of the world had to live with it. Only China and Russia had some capacity to push back. But you know what I'm saying? Could India say, because of the size of my economy, I'm not going to wholesale adopt everything that's in the EU statute?
See, Ajay, again, there are certain international commitments. Say, if everything started with OECD addressing AI way back in early 60s or somewhere, I don't remember the date, I think 1957 or 61 or something like that. From that time, there was an anticipation, and most of the countries which are signatory to OECD, they tend to follow it. With that, having said that one thing, the second part is, there are international commitments, as what I said, and there is also economies are closely working with each other. There are certain things, if I have to, as a country, whether I'm China, particularly India, or any country, you name any country.
But the EU star is not ascending. China's and India's star are. The European Union, its prospects seem murky at the present time. Therefore, why should China and India say we consider ourselves fenced in by what the EU decides on AI?
See, Ajay, when I started, of course, India has a different version. India has a different stand. In fact, we are very far ahead in AI. And so we are going to implement it very soon. But having said that, as I started with the version, that there are different countries' challenges, population, the way the environment, any AI system is being used, the deploy, the usage, the case usage, or objective, intended purposes. So that may differ. So it cannot be in replica or in toto. It can be implemented by any country. I doubt. I have a very strong doubt that at least every country will have a different way of addressing the things. But the core values will be, of course, trust, safety, fundamental rights, or the privacy, and they will be united with the difference in the way or the approach. But the unity will be definitely on the data governance, data lineage, or the data particular privacy. So there is no point to differ ultimately. And there are many things, of course, for the national security, countries may differ. That I cannot compromise on my national security. That is even provided in the EU AI. It doesn't bar that, because every member state has to agree. But there are many, more than 200 or almost 300 sectorial rules and regulations are also there. So many deviations are already inbuilt even in that EU AI Act. So for countries who are outside EU, definitely they have their own things, and EU AI Act can be a guide or a certain benchmark, but we have to understand. See, if I will say, if from the other schools' perspective, there are different schools who are talking about EU AI Act. Some says it is human-centric and the risk-based, whereas Some are saying no, it is not 100% risk centric. There are many deviations because, and there are many reasons because the risk somewhere it has been overweighted and no benefits risk benefit ratio analysis has not been carried out. So stricter rules for the stricter risk, it cannot be uniformly adopted. And even when there is a self-assessment, notified bodies will be also finding a difficulty. So there are many things which will be coming. So with this thing, which itself is not a time tested, it will be very premature to say that the countries will be adopting or discarding. But even if they will adopting or discarding, the parameters, the benchmark, or the situations, the environment, the technology, objective, intended purpose will differ from each country, the habits, the data inflow, data. So there are many factors we have to see in a holistic manner. So it cannot be something that, okay, EU AI Act has come, so we will replicate or adopt. No. Good things will definitely be inspiring. Good things will definitely go into the enactment or creation. But there will be many more things. And especially for India, I will definitely reiterate, even in the first episode also, I told in the G20 when it was in India, India made a statement that we will be setting a benchmark in AI. So with that factor, at least for India, I can say we are on a different footing.
Well, that's reassuring. I know that for India, look, ultimately all rules have to be tailored to the society that they're going to govern, and that I know for India and China particularly, it's national sovereignty is a big deal. But next, I'd like to turn to how the act has been presented. Now, you heard me say in the lead-in that the EU AI Act's been called a groundbreaking piece of regulation aimed at better ensuring improvements in the use and development of AI, as well as benefits for healthcare, transport, efficient manufacturing, sustainable energy, and all the rest of it. I'd like to turn to Michael. Michael, do you agree? I mean, or is that overstating the case? Or the proponents of the act and of AI more generally, are they perhaps promising more than they can deliver? I mean, because if you look at the prognostications of the '50s, the futuristic world we were going to live in, the world of the Jetsons, the flying cars, and the like, that yeah, they got some things wrong, but in terms of the projections of how far ahead we'd be, those expectations weren't met. So I'm just wondering, have they set the expectations too high in terms of what we can expect from AI?
It is the world's first legislative initiative for this, so we're already in uncharted waters. And the same way GDPR set the precedent for regulation of data in 2016, the same thing is happening here. So it is very difficult to say whether the approach is proportionate or not until the facts arise. And as always, the devil's in the detail and in the implementation. So the 2-year transition period we're about to enter will give us more information and data, and then maybe we could do further catch-ups on this to discuss how the implementation is progressing, maybe every 3 months or so. But I think the proponents are saying it's not strong enough, whereas industry is saying it's too strong. For example, back in December when political approval was reached, several lobbyists from Silicon Valley and others were strongly against this and vehemently opposing it because it's deemed to be too draconian. But if you take a step back and look at the risks, as Anand was saying earlier, some of the world's smartest people are saying we do not know how risky this is. There are even risks of which we don't know about, or risks that we can't quantify. So on that basis, I would say that this is probably not even strong enough.
Everyone's wondering, what are the Americans going to do? Will the EU AI Act inspire the US to take action in a similar way with comparable rules and regulations?
I think it will have the Brussels effect has been documented quite heavily, and I think there's enough evidence to suggest that will be the case. Whether or not they would use the word inspire is a different question. I'd say it strongly influences and affects the legislative policy, but we've already seen both at a federal, state level, various initiatives going forward. I believe California and Utah are fairly forward thinking in that sense. I think even the state of New York has something going through. So I think, yeah, there's reason to suggest that the Brussels effect will apply, but so they could also argue that the California effect or something like that also applies in reverse.
Anand, what do you think the Americans are going to do?
EU has adopted a risk associated, and of course, with a dual manner, human-centric and the risk assessment with certain deviations. But if you will see about US, they have already adopted, not only in this, but in the data privacy also, in a very fragmented way. So their approach has always been a fragmented approach. And same is the view with the AI. They don't have a full-fledged legislation, nor we could see as of now. Of course, they are working on, but there are certain patch laws or the executive orders what the President Biden has also passed, and an executive order to consisting the sector-specific guidelines and the federal orders to have a uniform legal legal framework in place. So that is what US has taken and they adopted on AI so far. Having said that, if I will also point out that there are evaluation of potential risk, but that risk is industry friendly. Whereas in EU model, you will find it is very stringent. It is not industry friendly. Of course, they have written in their recital to thrive upon the innovation at the same place. Though they want to safeguard, they want to have the safety and the health of the human beings and the fundamental rights rather. But at the same time, they have also put it that we don't want to compromise on the innovation. Whereas that stand is not in the US. US has always looked upon the business first. And of course, they want to adopt a framework because there are commitments all over the world wherever they have been part, whether the OECD or any standard bodies. From time to time, they have agreed, yes, we will have the regulation in the place or the AI system. So this is what I can make it out, whether from the blueprint for AI Bills of Rights, what the Biden has released so far, or any other mitigating AI harms, what they are emphasizing on. But there is nothing concrete. Even the data privacy, they are still to come with a very concrete, the uniform rather than the state enactments. So I think that it will take time, but maybe this time they will be faster than before, as AI is something keeping everybody on their toes.
Something I want to ask you on an India specific question is that, look, India is such a large player in the global IT services field. We recently heard about cyber attacks from China. And so cybersecurity is also important when it comes to AI, because a lot of the time you're dealing with sensitive proprietary information. What is India's AI preparedness in terms of cybersecurity and more generally, given how important IT is to the economy and given what an important IT player India is globally, that others are trusting India with their data? So you know what I'm saying? A data hack in India is not just a domestic matter; it's an international matter.
See, if I will talk about AI, India GDP will be contributed substantially by AI factors. And general AI could boost India's GDP by 359 to 438 billion by 2030. So that is representing almost a 5.9 to somewhere 7% increase. And if I will also see back, what are the statistics available? Over the last 7 years, the cumulative impact could reach to 1.2, 1.5 trillion. So there will be again a 0.9 to 1.1 annual percent annual growth to annual growth of GDP. So that is a very big number. And now coming to the IT, of course, India is ruling in IT supply with the manpower, or if you see the CTO, CEO of the biggest organization, whether the Google or any part of the world, you will find the Indians are leading strategizing, everything. So it is something that India has a substantive role to play when it comes to IT and particularly AI. So with that factor, I tell you, India preparedness started way back in 2018, like a national institution for transforming India. That is what is called as Niti Aayog, has published a strategy document. And that document was named as National Strategy for Artificial Intelligence. So I'm talking about 2018. So we were at par or sometimes we were ahead because even the consensus or drafting in the EU, AI also started somewhere 2020 and then 2021. So we are not behind, but we are somewhere ahead of those things. So India definitely outlines the vision to leverage AI for inclusive growth. What our Prime Minister also, Modi ji, always says, that we are looking for an inclusive growth. So that is coming out from our reports. And last year, also we had 8 committees which has given a report by studying an in-depth, the impact on the sectors, the many factors, parameters, the training, the risk associated. So it was a very exhaustive. With that in background, data privacy enactment has already been there, is already notified on 18th August 2023. It will be implemented somewhere in this year. Now, Digital Act, again, Digital India Act is also under the finalization. AI Act is also in the line of coming because there are many instances of the deepfake and all where the government has come and put their stand very clear that we are going to check these issues.
I wanted to ask you about that because here's the situation. I mean, earlier Michael was talking about KYAI, know your artificial intelligence system. Okay, AI is going to be increasingly used by banks in compliance. No doubt about that, right? Different institutions at different stages. But here's the thing. Deepfakes make it inexorably KYC inexorably more difficult. Therefore, if the technology that criminals are using is so complicated, is so advanced, might that not mean that you'll have to go back to pre-technology, pen and paper, face-to-face type verification for compliance? Because in an environment like that, perhaps low-tech is the only way to beat high-tech.
See, Ajay, I will say, though it is a tragedy, but I will say on an ironical part, because when Indians are leading this IT and all, so there are many persons who are using it in their way, where the deep learning, they are using it for the wrong reasons. That problem will definitely be remaining. But going with the commitment and the type of data privacy measures, data protection, and this AI Act definitely will be coming sooner or later. Digital India Act will be coming. Most of things will be either curtailed or contained. And even in any part of the world, even if they claim that they have a robust system in the place, then too there are breaches, which is reported from time to time. India has many different challenges. The population, the usage of the internet. We are the biggest population. We have so easy access to internet. We are among the top 3 when it comes to internet usage, the data accessibility. So there are many challenges. Look, our challenges, our technology, our regulatory frameworks will be on a totally different footing. That's what I started, and I have to again say at the cost of repetition. So with that, of course, the bank has also evolved with many bad experiences. They are working on it, and still they have come out with more robust system where the KYC, know your customer and all, particularly onboarding, they still have kept that particularly online, the digital onboarding. Even we are among first of the nations to have the UPI online payment, which has surprised even the advanced and the most developed countries. So that is the fact. So what we have led always, we have led as a principle, not that, okay, we have simply followed. So many more things will be coming, and we are really preparing very hard. There are many brainstorming sessions, all bodies are working, and the awareness, training, brainstormings, even the guidelines are coming. We are evaluating what can be the best structural framework or the which will be the best suited to the challenges in India. So definitely we will be coming out with the which much better version and not a replica of EU AI. I seriously doubt.
One last question, and it's related to what we were discussing, but I think it's more personal to you, in that it goes to how lawyers should think about and use and plan for and approach technology. We reached a few episodes ago. We had two friends of the show, Ron Yu and Donald Day. Both, one was a former regulator, the other's a law professor. So they know about, they have a solid exposure to the law and the regs, but they're also techies by background. The premise of the show was, what are the dangers of having non-technically trained lawyers dealing with matters where technology is, if not a big is if not it's not at the heart of the matter, it's a prominent feature. And you can see the dangers of having non-techie uh, or lawyers without backgrounds in science and engineering and technology STEM fields dealing with technology matters. Here we have with AI perhaps one of the most complicated types of technology, certainly from the standpoint of a layperson like myself. Somebody who's, again, not tech savvy at all, and lawyers are going to have to deal with this. Compliance people are going to have to deal with this. Policymakers are going to have to deal with this. What are they supposed to do? Where does this end? Or is this just a matter of, okay, admit what you don't know and hire the experts, hire the techies?
Well, Ajay, thankfully, I'm from the science background. So at least from my side, I can say
you're more fortunate than most.
yeah. So I'm well guarded. But having said that, on a technical note, see, I started with saying that this is a time where the lawyers have to have that sensibility to work in a TCL manner, techno-commercial legal. They have to understand the nitty-gritty of AI. AI is not that difficult. Of course, we don't have to enter into the coding or that technical part, but we lawyers have got to understand, whether the external counsel or general counsel, I mean the in-house, they have got to understand that what are the risks associated, what are the information which is going. And ultimately, they have to know, even for the GDPR or the data protection purpose, the DPDP also, or any jurisdiction they are in. They have to see further, they have to be conscious, they should be mindful about the data. So when they are mindful about the data, then they have to be mindful about that what technology is being used, because those declarations have to be made. So those things, at least they can understand. As I will say on a different footing, it is often said that if a lawyer or external counsel is dealing with a particular case or an industry, he or she is supposed to know the nitty-gritty of that industry. Then only they can deal that matter or the issue in a better manner.
But how deep should that level of that understanding of technology go? Because most lawyers, as we know, they come from the social sciences, they come from the humanities, or they come from the business world.
No, that's right, Ajay. There will be difficulty, but I can say that not because I'm from the science background, but it is not that difficult also. If they have to read, then they will definitely learn it. Not that every 100% they cannot be master in it, but if they will try and they will read it and they will try to understand their colleagues maybe there in the industry, because the privacy by design is the one of the important concept. You have to see even for the data protection or the data privacy. So for privacy by design, if you are discussing, you are understanding, okay, even if you are in a DPO and from a legal background, then the technical problems, which as a DPO is also there, then same situation is going to be here also. They have to understand what technology, because everyone is having accessibility to technology some or the other way. They are using the phone or app or something which is having a touch of the technology. And AI is something not an alien. When you are using Chat GPT, you have so many information. In fact, the public domain is also flooded with the information. And when you are in an IT particular industry, then you have got to understand. Without understanding, you cannot go far. You can walk, but you cannot go far. So you have got to learn it. But that is not that much difficult task that a person coming from the social, the humanity background, they cannot understand. And definitely, if they will put effort, if they can understand the difficult jargons of the law, then they can definitely understand the technicalities. Not to that extent what a expert is expected to, but they will definitely make a difference with their understanding, I'm sure.
And indeed, in my own life, I've seen some people go back to night school in the US, for example, to sit for the patent bar. You had to have a STEM degree, a science, technology, engineering, and math degree. And in some cases, people went back to night school to get their bachelor's in computer science, and then they were able to sit for it. And there was a time when patent lawyers were certainly making money up until the dot-com bubble burst. Those are all the questions I had for you. In the time we've got left, is there anything else you'd like to say? Anything you feel we didn't cover?
So, but I will say, what is lacking in when the usage of AI comes is the trust factor or the ethical principles. So the AI, particularly AI industry, as well as the legal framework, they have to focus more on the ethical principles and the ethical, of course, even the member unions though they have the similar charter, but it will be very interesting to see that how the ethical principles or the guidelines in non-EU areas will be evolving. And then maybe in a vice versa manner, maybe EU will be changing for the other jurisdictions which are going to adopt a new enactment for the AI. They may come up with something new. But having said that, I have to again say, we can expect something much better from India. So that is what I have to say. Otherwise, everything has been covered.
Anand, thank you so much for coming on the show today.
Thanks, Ajay.
Michael, thank you so much for your time.
Thank you.
And to our listeners, thank you. Until next time.